Hi, good evening everybody and welcome to Planning Committee this evening. My name is Stuart Keithley, Councillor Stuart Keithley. I shall be the chair this evening. Just before we start, got a bit of housekeeping. There's no fire alarm scheduled, so if the fire bell goes off we do need to leave, and it will be out the bottom from where I'm sitting, left-hand corner of the building, through to reception and then across the road to the car park of the Windmill, so we know everybody's there. Members, can you please ensure that your microphone's in front of you when you're speaking and you're logged in, so that we can pick up what you say on the recording. And for those that are coming to speak tonight, I'll invite you up and it'll be the same. I'll give you some instructions when you come to the table to speak, okay? What else have I got? Oh yeah, please note the meeting is broadcast live and it's also recorded. That's so that anybody not attending today can watch in to see what's happening. With me tonight on top table, I've got Kira Keller from Democratic Services, Sue Mullins, our legal officer, Emily Napier, our planning manager, and the two case officers tonight, Alison Young and Declan Jeremy. Emily, you have a statement to make for me, please, if you would.
Thank you, Chair. My role tonight is to provide impartial advice to committee members and to assist members in their decision-taking.
Thank you, Emily. Okay, so on to the agenda. Apologies for absence, item 1. Kira, please.
We have apologies from Councillor Fleming, with Councillor Pemberton as substitute, Councillors Hencher-Serafin, Holmes, Padgham and Passingham.
Thank you very much. Right, item 2, disclosures of interest. Members, please, any disclosures of interest? Councillor Adam first, please.
Thank you, Chair. Yes, I'm currently standing in the election division for Feldon, which pertains to 2 items on the agenda, items 4 and 5. And so, to avoid any doubt over impartiality, I'll be stepping down for those items.
Okay, thank you. Councillor Harvey, did you have your hand up?
Thank you, Chairman. Item 3 is an application which lies in my ward. Although I have had no participation in the Parish Council's discussions, in the interest of being squeaky clean, I will not I'll vacate my seat in order not to participate in the debate, but I will be reading a statement prepared by the Parish Council on their behalf.
Okay, thank you very much. That's it, thank you. Just to bring your attention to the update sheet and just to confirm that the application Oberry Fields, which is 2402944, has been withdrawn, so that will not be being considered this evening. Okay, the first application then is item 3 on the agenda. It's application 250061 Vary. It's the Exchange, Mill Lane, Newbold on Stour. The presenting officer is Alison Young. And Alison, if you'd like to take us through this application, please, when you're ready. When the technology's caught up. Some more coal on the fire. Okay, it's right. We'll be going in a minute. Sorry. So, no problem.
Thank you very much, Chair. The first slide shows the position of the site just to the south of Newbold on Stour. The applications for the removal of a condition relating to a 1987 planning consent. The condition relates to permitted development rights. This shows the site of the building and the surrounding land. This plan is actually from a 1989 consent. Unfortunately, the documents related to the 1987 one don't exist on the file anymore. So this shows the building on the land and the site as it was in 1989, which we assume is the same site as the 1987 consent. And this is just an aerial shot to show the position of the building and the site in relation to the village of Newbold, and the fact that adjoining development just to the north of the site has developed in the intervening time since the 1987 consent for the building, for the change of use of the building. So that new housing development adjoins the site now to the north. This slide shows the built-up area boundary for New Bold as set out in the neighbourhood plan for the village, which shows that the site just to the south of the village is within the built-up area boundary. And this is a photograph of the building taken through the entrance to the site. Thank you, Chair. The recommendation is to grant permission as set out in page 8 of the agenda, and your attention is drawn to the update sheet and the proposed addition of 2 further conditions within the recommendation. Thank you.
All right, thank you very much, Alison. Well, we have a couple of speakers registered on this, and as Councillor Harvey said earlier, he's going to speak on behalf of the Parish Council to start with. So if Councillor Harvey, you'd like to come up, you have 3 minutes to present on behalf of the Parish Council. Thank you. Do you think you'll need all of it? I'll give you a timer if you like.
I think I'll be finished before you're getting to 2.5 minutes.
Okay, thanks. Off you go when you're ready.
The Parish Council does not believe there is a valid planning reason for removing this condition, which allows the community to comment on any changes to a site identified as being important to the community. This is identified as a green space in the Treddington Parish Council approved neighbourhood plan. The Parish Council still wishes to be consulted about any changes to the site which this condition ensures. The condition number 2 of planning permission reference S87/0357 dated the 28th of July 1987 states, quote, notwithstanding the provisions of the Town and Country Planning General Development Orders 1977 to 1987, express planning permission shall be obtained from any further development of the land and buildings which form the subject of the application for planning permission. Original description of development, change of use of disused telephone exchange to high technology research and design of electronic and computer equipment. The Parish Council can see no reason for removing the condition, and our correspondence with the planning officer has given the assurance that it, quote, won't make any difference to any change to the site, end quote. The Parish Council therefore maintains its objection on the basis that if there is no difference to community consultation, why is the variation necessary? Thank you, Chairman.
Thank you, Councillor Harvey. Members, do you have any questions for Councillor Harvey? Councillor Parry, please.
Point of order, Chairman. I read a statement. I'm not in a position
to
answer on behalf.
Is that right, Sue?
Chair, the member can ask a question whether or not it's within Councillor Harvey's knowledge to answer is a matter for him, but the question can be asked.
Question can be asked. Yeah. Okay. You can ask the question, Councillor Parry, and if Mr. Harvey's able, Councillor Harvey is able to reply, then so be it. If you choose to do so, thank you.
Thank you, Chair. Obviously, you're not a parish councillor of New Bold. However, my interest was why the site was incorporated into the built-up area boundary for the NPD if they felt the parish didn't want any further development on that particular site.
The only thing I can constructively say to that was when the NDP was under discussion as the ward member, I was in favour of excluding it from the built-up area boundary, but the majority of the parish council and the local consultation was based upon it being within, and that was the basis upon which the NDP was approved.
Thanks, Councillor Parry. Thank you, Councillor Harvey. Members, any further questions? Following up from that note, thank you. That's all. Thank you very much indeed for your contribution, Councillor Harvey. Now we have another speaker. It's the agent and the applicant. So the agent, Jane Cashmore, is it? If you'd like to come forward, thank you. And Ian Shepherd, the applicant, to answer any questions, I think. Welcome, and thank you very much for coming along. You just need to press the right-hand silver button when you are ready to speak. I should give you 3 minutes to tell us about this application. Thank you very much.
Good evening. Firstly, thank you to the Planning Officer for her clear and comprehensive committee report which sets the matter out fully. I'd just therefore like to reiterate a couple of points. As you know, there are 6 tests that a planning condition has to meet. These conditions are set out at paragraph 57 of the MPPF, which states that planning conditions should be kept to a minimum and only imposed where they are necessary, relevant to planning and to the development to be permitted, enforceable, precise and reasonable in all other respects. A condition has to meet all 6 tests, otherwise it shouldn't be imposed at all. This application seeks to remove Condition 2 of Planning Permission S870357. Condition 2 essentially removes permitted development rights. It's poorly worded and isn't precise, as it's not specific to any particular type of development, also making it unreasonable. The MPPF paragraph 55 says planning conditions should not be used to restrict national permitted development rights unless there is clear justification to do so. The reason for the condition was to protect the visual amenities of the area. As your officer sets out, New Bold-on-Stour has grown considerably since the condition was imposed in 1987, nearly 38 years ago. Back then, the site was situated at some distance from the village with open land in between. Since then, the village has expanded and housing development now lies adjacent the site. Housing has grown down Mill Lane and permission has been granted for 5 dwellings northeast of the site. This growth is reflected with the site now lying within the Built-to-Para boundary. There's no need for the condition to protect the visual amenities of the area and no clear justification to restrict national permitted development rights. The condition is therefore also unnecessary. As your planning officer has clearly explained, the condition fails 3 of the 6 tests that a condition must meet. The condition is not precise, not reasonable, and not necessary. Given that it fails 3 of the 6 tests, the condition should be removed, and we therefore commend your officer's recommendation to you. We recognise that this may be a fairly unusual application to come before you. Although not pertinent to the determination of the application, to provide you with some context, the applicant has a long-standing relationship with the site, as it was once owned by his father. It's now owned by Mr. Shepherd. His circumstances have led him to require a new home. The removal of this condition would enable him to explore the potential of living on site through use of national permitted development rights. To reassure the parish council, they and other relevant parties would be consulted on any forthcoming prior approval application, as is part of normal procedure carried out by the district council. Your planning officer confirms this in her report. We also note no third parties have commented on this application. Just a point picking up from the parish council speech, and I wonder if officers are able to check about the point about it being a green space in the neighbourhood development plan. I'm not aware that that's the case. So in summary, since Condition 2 fails 3 of the 6 tests and isn't precise, reasonable or necessary, I hope you're able to support your officer's reasoned recommendation. Thank you for listening.
Thank you very much for that. Members, do we have any questions for the agent or the applicant? Yes, Councillor Adam.
Thank you. In the officer's report, reference is made to the previous consent, I assume the one from 2013, not being implemented. So you're saying that currently it's not being used as a residence?
That's correct.
Okay, thank you.
Members, further questions? No? In which case, thank you very much indeed for coming along to present. Okay, members, here's your opportunity to ask for points of clarification from the officers. And I have Councillor Adam to start with, and then Councillor Parry. I've got, yeah. Councillor Adam, please.
Thank you. Just with the confirmation that it's not being used as a residence, I want to just check my understanding of the permitted development rights for the site under its extant permission versus the one that may have lapsed, and if they differ at all. So essentially the last one that was approved, essentially the one that was approved in 2013 wasn't implemented, so does that fall away essentially? in which case you fall back to the previous one, which was implemented, presumably the one from 1989, which is use as office space. So my question is there a material difference in the permitted development rights for an office use compared to a residential use, which is the stated aspiration of the applicant? It's probably more of a technical just point, but just to confirm whether that makes any difference really.
Yes, its last use was as an office, so it currently has a Class E use, and that does affect what can be done under permitted development. Obviously, if it was a dwelling, then you can build all kinds of extensions and that kind of thing, whereas with an office use, there is permitted development under a prior approval procedure, which has been mentioned, to convert to a dwelling, but we would still have control over which I've set out in the report, things like transport, contamination, flood risk, etc. And there would still be a prior notification which would be advertised, and would, obviously the parish and the ward member would have a chance to consult. There is some limited rights to build extensions as a commercial building to be used for commercial use. And there is also rights to build things like fences, gates, walls, that kind of thing.
That's very helpful, thank you.
I think I would like to just provide a point of clarification on that this application is removing a condition. So in removing that condition, if even though the aspiration perhaps could be exploring the potential to use the building as a dwelling, there are separate requirements under the GPDO that would have to be adhered to in terms of the prior approval, which I think is what the officer is saying. So I just wanted to make that clarification.
Thanks, Emily. Councillor Parry, please.
Thank you, Chair. I don't actually think it's relevant to this particular case, but it would be useful for clarification because the parish council's statement made reference to the green space in the neighbourhood development plan. It would just be helpful, as the agent has also raised a query in this respect. Could we have some clarification on that and any potential impact it would have? As I say, we're looking at the condition rather than the overall site. But just as it's been mentioned this evening, I think it would be helpful for our committee to have confirmation.
If you give us 2 seconds, I just want to check the NDP just to make sure I'm on the right plan, and then we'll come back to you if that's okay.
Yeah, anybody else have a point of clarification? I'm looking around, I can't see any. And in fact, I was going to ask the same question that you asked, Councillor Parry, about the green space issue. You might also let us know the date of that NDP when you get it up, when it was made. Thank you.
So, sorry, just the policy is policy NE9, designating local green spaces, and there are 8 green spaces designated for New Bold-on-Stour. And looking at the map, which I haven't got access to the screen, so we might need to send this to the officer quickly to share. But I confirm that is not included on the map contained within the NDP, so we wouldn't regard that as designated under that policy.
Satisfied with that. Thank you. Thank you, Emily. And the date?
It was made on the 11th of July 2023.
Oh, so it's quite recent, 11th of July 2023. Okay. So if there are no further questions, we can go into discussion and debate. Who would like to start us off, please? Councillor Parry, thank you very much.
That's all right, Chair. I think the officer's report is concise, to the point, and in view of the conditions, particularly with the MPPF, I can see no material planning reason to refuse this, and happy to propose grant. Keep it swift and
to the
neat.
point. Yes, hang on. Could you just refer to the update report, Councillor Parry, please, because there's some conditions being included in there. So you just need to, with that proposal, If you could just confirm that you're happy with those conditions.
Sorry, Chair. Yes, I'm quite happy for the inclusion of those conditions.
Thank you very much. Councillor Redden.
Thank you, Chair. I'll keep it brief as well. Again, I think the report's very detailed. It underlines the reasons why this is unreasonable and imprecise and failing the MPPF tests. So I'm quite happy to second.
Thank you very much, Councillor Redden. So you're seconding Councillor Parry's proposal. Thank you. Any Councillor Parry.
Chair, sorry, I should have also mentioned, had this site not been included in the built-up area boundary, I think one would be looking at a slightly different response. But because it's included in the built-up area boundary in the neighbourhood development plan, that is the reason why there is no material planning reasons to go against this.
Thank you. Other members wish to speak on this matter? Well, I'm very happy with that proposal myself. It's in line with my thinking. It's removal or continuing with this particular condition is not in the spirit of the MPPF, and clearly things have changed in many years, such that the village has actually extended its boundary, and it has even included this building within it in the MPPF, which has only just recently been made. So I'm happy to take a proposal and the second, and I'd put that to a vote, please. If you could all have a show of hands. I think that's everybody in favour. Thank you very much. So committee resolves to grant 250061 Vary. That's the Exchange Mill Lane, Newbold-on-Stour, in accordance with the recommendations of the officers and the conditions that are set out in the update report, which are no outdoor storage, parking of 5 vehicles as maximum, gates and visibility displays. Thank you. Thank you all for that. Thank you very much for your contributions, everybody. Right, members, we're moving on to the next item, and I just note that Councillor Adams stepped away for that. So this is, let me just get to it. It's we are on agenda, because agenda item 4 has been withdrawn. We're agenda item 5, which is application 240261. It's an advertising. It's at the green at the intersection of Gaydon Road and Chapel Street, which is in Bishop's Itchington, and the presenting officer is Declan Jeremy. So Declan, when you're ready, if you'd like to take us through the application, please. Thank you.
Thanks, Chair. So the application seeks retrospective planning permission for the erection of an A-board advertisement sign located at the intersection of Gaydon Road and Chapel Street in Bishop's Itchington. The proposed location is marked by the black dot on the screen here. This slide provides you a closer aerial view of the land, with the application site outlined in red. The land is an area of open green space that belongs to the county highways, and it's a very visible area from both Gaydon Road and Chapel Street. The red dot on this map highlights the precise location of where the signage is proposed. It's obviously close to the junction where the roads meet. Here, the proposed signage, you can see the proposed signage denoted by the red dot on the screen, and the village store can be seen by the red star. There's about a 200-metre separation between the two. Here's a proposed signage design and scale. It features a black, grey and white colour scheme and is of a standard A-board dimension, measuring 110 centimetres in height by 68 centimetres in width. The sign displays the name of the store, a directional arrow and a list of key items for sale. This image shows the sign in situ, positioned on the green, with Gaydon Road and the church visible in the background. The open space already contains various street furniture and infrastructure, including a telephone box, post box, notice board, telegraph pole, and street sign. This image shows the sign from Gaydon Road. You can see it without not being in situ, with Chapel Street to the rear. And finally, this is a close-up image where you can see the details of the advertisement, including the name and promotional content. And the reason for the referral outlined in the report has been updated. The Head of Development, in consultation with the Chair, have decided to refer the application to committee for decision under paragraph 20B of delegations of the Head of Development under the Council scheme of delegation to officers. This is due to the item being referred to committee in error, as advertisement applications do not fall within the relevant criteria for referral under paragraph 20A. The delegation to the Head of Development However, as a ward member, parish council and applicant have already registered to speak, the Head of Development has utilised his referral powers in consultation with the Chair of the committee to refer the application to committee for determination. Officer's recommendation is to refuse the application as per the reasons set out within page 28 of the report. Thank you.
No, you're done. Declan, thanks very much for that. Okay, so it's been referred in error, but we're listening to it anyway. So we've got some presentations as well, some speakers. So let's listen to those. We've got, first of all, Councillor Dugmore from Bishop's Itchington Parish Council supporting the application. Good evening, Councillor Dugmore. Thank you for coming along. I'll give you have 3 minutes to speak, and you just press the button on the right, which the little red light comes on.
Okay.
I'll give you, if you think you're going to take the 3 minutes, I'll just give you a 30-second
Appreciate
heads
that.
up as we're coming towards the end.
We should be well within.
Yeah, super. Thanks very much. So
Okay.
when you're ready, thank you.
Lovely. Okay, thanks everyone. Good evening. Bishop's Itchington Parish Council supports this application. It's consistent with the intents of policy BINDP 7 in Bishop's Itchington's Made Neighbourhood Development Plan. This states that the retention of the following community facilities will be supported in accordance with core strategy policy CS25, healthy communities. Policy BINDP 7 identifies the village store as a local shop within the village, as one of 11 specified facilities within there, and states that proposals to enhance and improve existing community facilities will be supported. This is an enhancement of visibility for a business specifically named in that policy, which does not have the benefit of being positioned on a main thoroughfare through the village. As an effort to enhance the success of the business, this is clearly an enhancement or an improvement. The officer refers to there being no evidence to demonstrating the critical role of the notice, and then goes on to say that the business is a distance from the proposed location of the A-board. This view is somewhat conflicted, as it is self-evident that distance from the main road is exactly what gives the sign its criticality, especially now that, for example, the co-op occupies such a comparatively visible position on the Gaydon Road. It could be argued that the wording of CS9 paragraph H is excessively restrictive, as it denies the purpose of an advertising sign, especially where the business is less visible from the main thoroughfare. We would challenge the suggestion that a precedent is being set for future applications of this type with regards to massing or clutter, as future applications for A-boards in this location will be in the context of any previously permitted A-boards and shall each be considered in respect of the circumstances prevalent at the time. So with respect to the reasons for refusal, on the first point, the matter of the text content is something that clearly can be addressed, perhaps in its extreme, control by condition if necessary. On the second remaining point, the officer raises concerns about precedent and clutter if others make a similar application. This is not a fair assessment as they are recommending refusal based on hypothetical future applications, something for which there is no evidence right now. The application needs to be considered on its own individual merit, and if massing occurs due to future applications, should be dealt with in those future applications.
That's 30 seconds now.
That's all. Thank you.
Thank you. I didn't realise you were just about there. Thank you very much for that. Members, do you have any questions for Councillor Dugmore? Yes, Councillor Pemberton, please.
Thank you, Chair. Good evening. The Neighbourhood Development Plan identifies a number of businesses that are critical in your in terms of the plan, including the application business. Can you just confirm what other businesses are identified in the NDP, and geographically speaking, are they where are they in the village? In terms of, you know, would this site be a potential location for other hoardings?
So, as examples, obviously we have the village store. We have there's a hair and nail salon in the village. There's the pub. There's the Greaves Club. They're all located within the centre of the village, which is to the east of the main road. They're not placed on the main road. The only business operating on the main road that's directly visible from the main road is the co-op. So the co-op at the moment absorbs all of the passing trade there. Hence, you could argue another case for criticality of making passing trade aware of the businesses placed in the village centre.
Thank you. Just to follow up on Councillor Pemberton's, are there any other signs that direct people coming through the village to local services?
There are,
you know, like a brown sign that says "Let local services."
There are two very generic and arguably outdated signs on the main road. One of them's only just come back into view actually because it was lost in a hedge. But there is a refreshment sign at the end of Fisher Road, and there is a sign identifying local shops and post office, if I remember correctly, opposite the entrance to Chapel Street. Until we laid the hedge, you couldn't see that.
Okay, thanks for that. Councillor Parry.
Thank you. I note in the officer's report it highlights the A board is movable. Does the sign remain static, or is it moved out of outside the operational hours of the village shop?
I think that may be a question better answered by the applicant.
Okay. Yes. Any further questions? No, it doesn't look like. Thank you, Councillor Dugmore. Thank you very much indeed for your presentation and for coming along this evening. Thank you. So our next speakers are Sabina White and Orla Horsman? Orla, sorry, Orla. Who are the applicants. So you also have 3 minutes. You decided how you're going to... Are you going to split the 3 minutes, or one of you talking and the other answering the difficult questions? All right, okay, super. So if you turn on your microphone on the right, will you need 3 minutes or less?
I don't know.
Shall I run the timer then? Thank you.
Better,
I will.
yeah.
Thank you. When you're ready.
Thank you for your time this evening. We started this application process on the 1st of December 2024. On the 13th of January, we were advised that the application would have a recommendation for approval. However, after talking with the manager on the 28th of January 2025, we were advised by the planning officer that the recommendation would now be refused. Our response to this is that the positioning of the A board is necessary to highlight the store's existence. It is at the top of the road on which the store is situated and gives information about what we offer and where we are. The shop is a protected amenity within the local plan and is considered an asset to the village, which should be protected. Amongst some of our services is a newspaper delivery service which reaches across many other local villages, providing a service to people who are isolated or unable to access shops. When the co-op moved to the top road, it diverted traffic away from the centre of the village and thus impacted on our trade. We at this point felt it was essential to have some form of advertising about our existence near the main road through the village to show people there is a shop and a cafe within the village and to encourage greater footfall, without which the store would fail. We have clearly laid out both in the original application and in ongoing communications the reasons why it's so critical for us to have an A board on the top road in such a rural location. Whilst the local plan may list 10 businesses, the only ones that now exist down our road are us and the hairdressers. The co-op has copious external signage outside its huge unit with many A-boards on their plot on the main road advertising all their goods and services and huge posters on their fences. The pub and chip shop have their own refreshments brown sign. There is no evidence to suggest that us having a sign will begin an influx of other A-boards. There was already a parish notice board advertising both business and community activities on the green. It has also been stated that policy H3 specifies that signage should only include the name, nature and services of the business, and advertising for specific brands or products should be avoided. We offered to reduce the writing. However, planning felt this would be insignificant for all their other reasons. However, everything that is on the board is within the brief of what is allowed as they've listed themselves, which we took into account before designing it. It says who we are, where we are, and what we offer. There are no other brands or products detailed. There are only 2 muted colours on the board, which is in keeping with the store's design and aesthetically is vintage rather than modern in design. The highways team who own the land have clearly stated it poses no risk in terms of being a distraction or public nuisance, and they are in agreement with its positioning and placement. Our business needs the A-board to promote where it is. It has been designed with the community in mind and has not been a point of contention within our community. Our parish council and district councillors have supported the application on the basis of their understanding of our need and where we are based within the community. We ask that you give the fullest consideration to the need which led to the application in the first place and take into account the support we've had from our local community in it being there. If we can't do something which has no detrimental impact on anyone else but could mean the difference in remaining open, we can only hope that you understand and support our application. Thank you.
Thank you very much for that. That was very interesting. Members, do we have any questions, please, for the applicants? Yeah, we've got a few coming. So, Councillor Parry first.
Thank you, Chair, and good evening to you both. I wonder whether you can advise the committee of the profile of your customers. Are they predominantly from the local community, or do you get an amount of passing trade?
We get a lot of passing trade. We advertise outside of the area as well, so people potentially know of the store but don't actually know exactly where it is, so it helps point people in the right direction. If we just relied on our local community, we probably wouldn't survive because of the size of the area that we're in. So we have to attract passing trade in order to keep going.
Thank you for that. Councillor Harding.
Thank you, Chair. A few points on the status of the land that it's on. I note it's on highway land. You say you've written to the County Council to obtain their permission. Have you received a reply to that?
Yes, we've received a email reply to say that it would be supported by the case officer that was reviewing it.
Okay. Secondly, it's a movable sign. Can we be sure that it won't be moved to obstruct visibility from the side road?
It's full of sand, so it's really heavy, because we wanted to make sure that that wouldn't happen and also that the wind wouldn't blow it and it cause a nuisance. So we've made it extremely heavy. It's hollow, and I've filled it all, the whole hollow, with sand. So it's not easily movable, and we've not had any incidents of it being moved out of place.
Okay. And finally, if I may, with my traffic engineer's head on, principle of designing signs is that you have minimum amount of text on it, because drivers are going past quite fast. They're going to have a limited time to be able to take that information in. So you keep it condensed. If a driver is distracted by this and smashes into somebody, who is liable, and do you have public liability?
I'm sorry, that's an out-of-order question. I'm sorry.
Yeah,
you can't go there. You can't expect the applicant to answer that.
I just want to know if you have public liability insurance covering this.
Well, it's not, I don't think that's a planning issue. It's not a planning matter. It's not a matter for us to consider, Councillor Harding. That. So thank you. Have you finished with your questions then? Yeah, thank you. Councillor Eden, you had your hand up for a question as well.
I did. Thank you, Chair. Hello. Good evening. We've heard some talk in other speeches and presentations about the brown signs around the village. Is that something that you've looked into or might consider if perhaps this doesn't come about?
Yes, we do have a potential plan B, but there is already the one brown sign. The advice we've had is that obviously you have to pay an upfront application with no guarantees for approval. It's a considerable sum, but also with the brown signs, I believe there are other criteria that we potentially wouldn't meet in order to get it in terms of tourism, footfall, and what it means. The one that is there points to the pub, the local chip shop, the community centre, Memorial Hall, so I don't know whether that allowed, because of the tourism level for the Memorial Hall and the community centre, a greater footfall. But we have explored it, yes, and are still looking into the potential of the white sign being changed if this fails. So.
Okay, thank you. Happy with that answer. Councillor Pemberton, please.
Thank you, Chair. I think, based on what you said about the weight of the sand that's securing the sign, but I think Councillor Parry was trying to establish from the Parish Council whether the sign was taken in at the end of hours, or is it just left out all the time? Just to clarify if that's the case.
It's left out all the time.
Okay, thank you very much.
We open at 5 a.m. in the morning, so
long days. Yeah, no, it was a point that the Parish Council couldn't clarify.
Thank you, Councillor Pemberton. And members, further questions? In which case, thank you very much for coming along and explaining your application. Thank you. Got one final speaker on this. It's Councillor Rock. Good evening, Councillor Rock. Welcome. Councillor Rock, you've got 5 minutes. Do you think you'll need all 5? Well, I'll give you 30 seconds as you approach 4 minutes 30.
I have a certain reputation, of course, but
don't worry, I'll get the timer on. So when you're ready, anyway, you can go when you're ready. I'll start the time.
Good evening, colleagues. First of all, can I say I'm speaking on behalf of both members because we have a 2-member ward, and the same applies for the update sheet. So I'll launch in. I think we've got a couple of pictures. So could I have the other slide, please? Thanks. Although neither ward member originally made representation of this application, we did not find it would warrant a refusal or, strangely enough, a committee referral, although we seem to have a technical difficulty with that, judging from what we've just heard. It's difficult to see the planning harm that this application represents. Warwickshire County Council has not objected as highway authority, nor as landowner. Warwickshire County Council themselves offer their own roundabouts for advertising of businesses, which can never be at the site of the business advertised. The applicant has offered to simplify the wording if that is somehow offensive, which has just been referred to in a question. So we are left with a possible policy objection from CS9, I've bought the book, CS9 paragraph D, that the sign is not within the curtilage. Yet this authority tolerates a great many A-boards in the same road as these council offices here in Stratford town. These are placed on the footway and clearly not in the curtilage of the business they promote. At Southam, we haven't got the right slide there. But anyway, we'll live with that. At Southam and Tesco's, a number of other businesses have signs 200 metres away from the premises they promote. The difference is they don't seem to have applied. So we could go to the other picture now, Declan, if we could. The site is a triangular grass area forming no obstruction to anybody. In any case, the explanatory wording in CS9 paragraph D makes clear that matters such as size, design and safety would be the only reason from invoking the clause as a reason for refusal, which to the ward members or to the parish council do not seem reasonable or applicable in this context. The last sentence of CS9 paragraph D carries some ambiguity. It says advertisements should be located at the site access. The business is indeed accessed from the location of the A board, from the junction of the B road via 200 metres of adopted but unclassified highway. Are we saying it would be okay if it was not a public highway? Time for some common sense, I think. However, whatever paragraph CS9, paragraph D says, in the Bishop's Hitchington Parish, that clause is balanced and outweighed, in our view, by the Neighbourhood Development Plan, policy BND P7 to support the business, which is in clear sight of the A-board location. And you can see it there, that picture I've taken, you can see the canopy there in the distance, 200 metres away, and that's standing next to the triangle of grass. Speculation that other applications might come forward in adverse circumstances, surely you can't speculate about other applications. You must look at the application before you. And I can talk a bit about the brown signs if you want to talk about that. Thank you very much. I have completed, I think, within the 5 minutes, Chair.
That's
Shock
a miracle.
horror.
That's a miracle, Councillor Rock. That's 3 minutes 45.
Chair, are we recording this?
It's all right, I think we've just caught it. Members, any questions for Councillor Rock, please? Yeah, I'm just wondering if I had any, actually. I think, well, I suppose what I'm going to ask you is this issue about the relationship of the sign to the store, and whether or not there's an issue with the relationship of the other signs, the brown signs that you mentioned that you could speak about, to the store as well. And you've just shown a photograph that you say was taken from the side of the green where you could see the store, the awning. Could you comment on the brown signs and how you see the relationship of the sign with the store again, please?
I don't know, it would be helpful if Declan could put up the map, actually. Well, that'll do. The B4451 is a sort of, that's the Gaydon Road. It's a sort of main road through the village on the way to the motorway. And I think the passing trade was mentioned. And you can see Chapel Street there. There's several signs, I could count them all off, that come off that road and into the sort of heart of the village. Some of the businesses referred to the pub and the hairdressers and all those sort of things. There are different roads that lead off there. The shop is really the principal one with the awning that I showed earlier on that comes down there. So if you're going to attract passing trade, you really need the sign that points down there. Now, not so much a brown sign, there's a white sign with a picture of, I think it's got an apple on it. I'd have to look at the others, but that's the sort of rather ambiguous refreshment sign on it. Since I've got interest in this application, I noticed in Southern there's a sign. That's fine.
The location of these other signs, could you indicate to us where they are? Are they close to where this little green is?
Well, I don't want to tell you, I don't want to mislead you quite where the other sign is, I don't know.
Okay.
I think it points more to the centre of the village. This particular business is not quite in the centre of the village, so it wouldn't be helpful.
No, it's okay, thanks. It's okay. It's all right, thanks.
But there are several roads, that's the point.
Yeah, sure. Pointing to the local services off the main road.
Yeah. So
okay, thank you. Members, anything else? No, thank you very much, Councillor Rock, for your contributions. Valuable, thank you. Okay, members, points of clarification to the officers, please. Did you have any? Councillor Scorer is indicating his question.
Just a quick one. Could I have another look at the photograph on with the A-board, the actual A-board pointing down to the shop, please?
Perhaps zoom in on it a bit.
And sorry, back again. The one. That's it.
So are you happy with that? I mean, the car's on the main road, isn't it? The car's on the main Gaydon Road, so it's the car's seeing the sign as it's passing. Okay. Further questions? Councillor Harvey.
CS9D advertisements. It reads, advertisements should be located within the curtilage of the premises to which they relate or at the site access. The key word to me is the word should. Can I have the officer's interpretation that these words mean that there are only two alternatives in order that this condition, this policy, can be complied with, i.e. the advertisement sign must be either within the location of the curtilage or it must be at the site access. And in interpreting the word site access, is there a legal definition of site access? Can it be 200 metres away from the curtilage of the property? That's my first question.
So I agree with what you said about that it should be located either to the frontage of the shop or not. And with regards to the legal reasoning behind site access,
I would say there is no legal definition of site access, but when we are considering site access, sort of in terms of sort of valid application, where the red line goes, we would determine that the site access is the point at which the application is accessed from the public highway. But as I say, it's not a legal definition, and I think that would be how we would look at it. We would not necessarily consider that a junction is a site access where it is, detached from the application site, the red line itself.
Thank
Did you want to clarify
No,
site access?
No, I accept the words that have been provided.
Okay.
My second question is even simpler. The policy uses the word should. It doesn't use the word must or is required. And therefore, is it an acceptable interpretation to consent to an advertisement which is neither within the curtilage nor at the site access, because the policy merely requires should, not must?
Sorry, I think Sue might want to ask this because she just looked up, she just commented on exactly that, the word should, and whether or not that implies some degree of interpretation.
My general interpretation would be that must allows no scope for derogation from the obligation, whatever it is, whereas should would allow some form of exception. It's not for me, should isn't an absolute, it's a starting point.
Councillor Harvey, happy with that?
I'm very happy, and I think others, members of the committee, will equally have found that helpful.
Yeah, very helpful. Thank you, Sue. Councillor Pemberton.
Thank you. To cover the point I was going to cover, my interpretation and my understanding of how that wording would be tested in court. Should is not, it's not must. So it allows wiggle room, and that confirms. Should allows wiggle room.
Thank you. Have you got any further questions? Or that was just clarification?
That was
An understanding.
It was already provided.
Thank you. Good. Members? Further questions? Nothing? Okay. Thank you very much for that. Right, in which case we can move on. No further points of clarification. We can move on to discussion, debate. Councillor Pemberton, thank you.
Thank you, Chair. At the top, I'm going to say that the officer has prepared a good, clear report. I understand the rationale that the officer has used throughout to come to the conclusion that the recommendation is to refuse. However, as a decision maker, I'm going to take a different view and will seek to look for a seconder for approval. First of all, I'm minded to consider the neighbourhood development plan, which clearly identifies a number of businesses that should be supported in order to create a vibrant, sustainable community. I then look at paragraph 8 of the NPPF, and I draw members' attention to paragraphs A and B, the economic objective, the social objective. They're both intertwined around building strong, responsive, competitive economies, supporting strong, vibrant and healthy communities. This business does that. The parish council are to be commended for having a neighbourhood development plan that addresses these issues, and I think we should be looking to support NDPs where they do that. There are precedents in my own ward where the parish council, in order to address at that time a larger retailer coming into the village, they actually created a set of boards advertising the smaller businesses in Bidford. So I think I absolutely understand where the officers are going. However, I think that we can hang our hat on the NDP from the parish council. We can hang our hat on paragraphs A and B, paragraph 8A and B of the NPPF. And I would also suggest that there's no environmental, looking at paragraph C, there's no adverse impact. I might observe that that parcel of land could be described as already cluttered with a postbox, a rudimentary 1980s designed telephone box, not even a traditional red phone box, the sort of steel BT ones, telegraph pole. Overall, I absolutely understand officers, and I have no concern about how the officers have come to where they've come to. I think this is one where there is broad support from the community, from the parish council, from the ward members, and I think we should take a pragmatic approach. And if anybody is prepared to second me on that with those broad reasons for approval, details of which I'd be happy to delegate to officers, I'm looking for a seconder. Thank you.
Thanks, Councillor Pemberton, for that. If we're minded, you'll take that as a proposal. If you're minded to go against the officer's recommendation for refusal, we need to consider some conditions that would be required. But we can talk about that in a second, if you like.
If we get to that point.
Yeah, okay, thank you. Councillor Harvey.
Thank you, Chairman. I'll happily second. I take the point that Councillor Pemberton has made about the officer's report. I completely understand how CS9D has figured in this conversation, and but for the word should, I would be on the opposite side of the argument, because you can't have policy and ignore it at your whim. It's there for a reason. This sign is not within the curtilage, and it's nowhere near the site of access, despite the verbal gymnastics that Councillor Rock went through to try and persuade us otherwise. But because the word should allows wriggle, I think in this instance, given the support from the parish council, given the support from the members, given the lack of opposition from highways, given the state of the green, which is already on the green, I can't see any harm or reason not to approve this, simply based on the wriggle room of the word should. I would say, however, that I think the question of what is actually written on the board is a matter for agreement between with the officers' consent being required for that, but subject to that, and perverse though it may seem in my pedantic way, I will happily support Councillor Pemberton and second.
Thank you very much, Councillor Harvey. Councillor Scora.
Thank
Yes,
you. I just agree with the councillors when looking on the green with the other obstacles on there. I didn't find the A-frame very offensive. My eye was drawn to the quality of the hedge laying the other side of the road.
Okay. Thank you, Councillor Parry.
Thank you, Chair. Fully in agreement with what fellow councillors have said. I would just add it actually is in line with the core strategy, I believe CS22, which supports economic development.
Chair, happy to have that as an additional hook.
Agreed.
Okay, thank you, Councillor. Oh, Councillor Harding, you want to speak?
I'm in a minority here. I go with the officer's recommendation. I'm very surprised that County Council hasn't picked up on this. They have a very strict policy on sign proliferation, and especially homemade signs put up on highway land. I'm very surprised at their position. I think this business would be far better served by a brown sign, which would be far more noticeable, and they should investigate that. And therefore, I will be voting to support the officer's recommendation.
Thanks, Councillor Harding. I would just add to that on page 24, in terms of the consultation response from Warwickshire County Council Highways, just clarify that there was no objection from a highway safety perspective, although the applicant would need to consult County Highways, which I think they said they had done. Thank you. Hang on a sec. Anybody else like to add anything? No? Okay, in which case we've got a proposer and a seconder, Councillor Pemberton and Councillor Harvey, and we've got some proposed conditions as we're potentially minded to go against the recommendation. Do you just want to take them through those conditions, Declan?
Yeah, so quite simple, just the two of them. The first one would be it's a standard advertisement consent condition that it would expire at the end of 5 years from the date of the application. That's throughout for every advertisement. And secondly, this is up to members to decide whether or not we're going to include a third condition to simplify the information on the board. If we don't, then it will simply be that it's retained in accordance with the approval. If not, that will need amending to...
Sorry, Declan, you're saying that the suggested wording has already been put forward by the applicant as simplified wording?
From what I remember, it hasn't been put forward. It didn't get that far because we considered the application unacceptable on other grounds.
Councillor Pemberton, how do you feel about the wording on the sign?
I'm comfortable for us to have a condition that simplifies the wording, because that then starts, having gone against the officer's recommendations, and we're saying that there are specific circumstances to allow the advertising board in this location. That does not of itself mean that we should move away from the standards that we ordinarily impose around the information that's on the hoarding. I appreciate from the applicant's point of view that's a further hoop to jump through to simplify the wording, but I had already had it in my mind that we would be looking to simplify the wording to ensure it's on all fours with that part of the policy.
If I can come in. The application, I understand, is submitted in retrospect. We have had details submitted with the application. I am not comfortable, and I would move to my legal colleagues to advise otherwise, that would be an appropriate condition that we could put on.
I'm happy to go with officer's recommendation on that if they feel it's not an enforceable or appropriate condition. Who am I to say otherwise?
I think on that basis, just to make it clear then, what we would be recommending were members to move with this motion is the first condition would be our standard time condition for advertisement consents, which is slightly different to a normal planning application, and that the development would have to be retained in those details that have been approved.
Okay, happy with that? So essentially then, we've got a proposer and a seconder to approve this application based upon the weighting that we applied in debate to CS9. We don't see a conflict with CS9.
On the basis of
Should rather than must. The importance of paragraph 8 of the MPPF and the support of CS22. And the support of the NDP and the fact that these businesses have been identified. So, okay, on that basis then, I think we can move to a vote on this, members. So if you'd like to indicate by show of hands those in favour of this proposal and those against. So it's just one against. So that's carried. So this committee then resolves to grant 240263 that's an advertising at the Green, the intersection of Gaydon Road and Chapel Street, Gaydon Road, Bishop's Hitchington. And that's in accordance with the conditions that had been suggested by the officers. You will delegate those conditions to you for finalisation. So, members, thank you very much indeed for that and that decision. Okay, thank you. Okay, so just moving back to the agenda, urgent business item 6, nothing, in which case I can close the meeting. Thank you very much, everybody, for your contributions this evening. Thank you.